Court packing 101 sounds dirty, doesn't it? I need to explain to you what the court packing is because I can't believe I've gotten inundated with emails and we've gotten a bunch of phone calls into the program asking what court packing is because the Democrats keep talking about court packing. Let me give you the historic lesson on court packing. Back in World War II, the Supreme Court of the United States was decidedly more conservative than even the conservative majority is right now. And they consistently killed parts of Franklin Delano Roosevelt's New Deal program. They decided much of what he did violated the Commerce Clause, and that it wasn't something that the federal government could do. And it was restraining Franklin Delano Roosevelt's efforts for a nationwide policy for rebuilding and recovery during the Great Depression. Ironically, most economists today now acknowledge and agree that Roosevelt's policies to get us out of the Depression actually caused the Depression to stay longer. But at the time, they really didn't know. This was something new at a global scale, coupled with a world war. They needed to do something. And the Supreme Court of the United States kept telling Franklin Roosevelt, you can't do what you want to do under the Constitution. So Roosevelt, who had a majority in Congress at the time, a Democratic majority in Congress at the time, proposed court packing. And Roosevelt's proposal was that the president would be allowed to add additional seats to the Supreme Court when any member of the Supreme Court got to be 70 years old. Right at the time, that would have given Roosevelt 6 seats on the United States Supreme Court. 6 out of 9 of the justices of the Supreme Court were 70 or older. Now, Roosevelt, of course, went on to serve 4 terms as president, so he would be able to fill most of those seats. But his thinking was he would either force those members at 70 to retire, thereby causing term limits outside of constitutional parameters. Supreme Court and federal court judges serve for life. So he would essentially incentivize them retiring for love of the 9-seat majority, or he would be able to add seats to the majority for each person who is 70 or older. And it was called court packing, adding seats to the Supreme Court, packing the court with your side. It would have made the court an instrument of the Roosevelt administration. It did not appear that it would pass the Congress, but there were doubts as to whether or not it would pass the Congress, particularly if they kept striking down Roosevelt's agenda. And so the members of the court, being astute politicians in addition to lawyers and judges, did something that's called the switch in time that saved 9. The switch in time that saved 9. Everybody learns about it in law school. It has an encyclopedia entry. And it came in West Coast Hotel versus Parrish. It was a 1937 case, so it was before World War II. I'm sorry. This happened before World War II. The president had wanted to pack the court. He would have added a total of 15 seats to the court. And there was a case, West Coast Hotel versus Parrish, in 1937. In that case, Owen Roberts, an Associate Justice of the Supreme Court, switched sides from where he had been philosophically with the court, and he joined Chief Justice Hughes, Louis Brandeis, Benjamin Cardozo, Harlan Stone, and upheld a minimum wage law. The decision came 2 months after the court packing scheme, and Roberts has been considered a strategic vote to kill the Lochner era. Now, what is the Lochner era? This is a 40-year period where Congress decided the Supreme Court decided Congress had no power under the Commerce Clause to regulate intrastate commerce. Intrastate commerce. Essentially, what the courts had consistently held is that the government, the federal government, had no ability to regulate commerce inside states, only between states. And the result was that Congress wanted to require states to do certain things economically, and they weren't allowed to do it. And Roosevelt was getting frustrated because what he was trying to do was pass federal laws that would regulate commerce inside states. And they refused. The Supreme Court said, you can't do this. Well, Lochner is kind of a rallying cry today for a lot of conservatives. It was a big case. It was a 5-judge majority held that New York law requiring the bakery employee hours had to be under 10 hours a week and 60 hours a week violated the due process clause. Their view contained a right to freedom of contract. They said it was unreasonably unnecessary and arbitrary interference in the right and liberty of individuals to contract. There was a federal case. Lochner, you could not at the federal level with federal law or with state law for that matter restrict the contract rights between individuals and businesses. And this is something that infuriated FDR. It infuriated a lot of people. The case came down in 1905, and it set precedent to 1937 with West Coast Hotel versus Parrish. The Supreme Court had used the Lochner case to strike down a series of federal labor laws related to the individual states. Federal labor laws regarding minimum wages, federal labor laws regarding contract rights, federal labor laws regarding work hours, things like that. All that kept getting struck down that FDR wanted by the time he became president, wanted them as part of his New Deal package, and the Supreme Court said no. So along comes West Coast Hotel versus Parrish, and Justice Owen on the Supreme Court reversed his prior stances on the Commerce Clause and Lochner. And essentially, it overruled Lochner and allowed FDR's New Deal policies to go forward. Roberts switching his vote and aligning in a 5-4 decision contrary to where he had consistently been is referred to as the switch in time that saves 9. It is referred to as a political maneuver by Roberts and the Supreme Court to avoid Franklin Roosevelt being able to get a majority to stack the Supreme Court, to pack the Supreme Court, if you will. Court packing became the idea of piling members to the court to get your way. And it failed. Democrats and Republicans have consistently opposed court packing since it failed, since the switch in time that saved 9 in 1937. But over the last year and a half or so, the Democrats, as they've seen Republicans putting conservatives in Court of Appeals positions, after the Democrats, and this is important, after the Democrats themselves got rid of the judicial filibuster, the Republicans began piling conservatives into the Court of Appeals. Now, you need to understand this history as well because it shapes the fight we're seeing right now over Justice Ginsburg's seat. When George Bush became president, the Republicans had a very slim majority, and Jim Jeffords of Vermont switched parties, denying the Republicans a majority. As a result of that, the Democrats slow-walked Bush's ability to fill circuit court seats. When the Republicans took back the majority in 2002, the Democrats in the minority continued to filibuster to prevent President Bush from filling circuit court seats. The Republicans threatened to get rid of the filibuster and came close to doing it. But a bipartisan group of senators, the Gang of 9, I think there's a Gang of 6, there are all these gangs in the Senate. It's gang warfare in the Senate. They came together and they structured a compromise whereby they would get together and they would tacitly bless certain appellate court nominees, and those nominees could move forward. And the more conservative ones that Bush wanted, they would move forward in states that were controlled by Republicans, and the Democrats would essentially get the right to pick the ones who would fill the seats in states controlled by Democrats. And a bipartisan group would bless the ones in states where the Senate delegation was split. When you get to Barack Obama's administration in 2009, as payback for the Democrats doing what they had done, Republicans began filibustering Barack Obama's circuit court nominees. And again, there was a bipartisan compromise to be able to bless certain nominees, but it wasn't enough for Harry Reid. And Harry Reid decided there was no longer a reason to compromise. The Democrats controlled everything. It's time to put more progressive justices or judges in the federal courts. As a result, Harry Reid decided to scrap the filibuster only for circuit judges and other nominations, not for the Supreme Court. It was just one little sleight of hand. He would tell the Republicans you can still filibuster the Supreme Court, but the rest of them you couldn't. And everyone largely knew if the Republicans filibustered the Supreme Court, that was going away too. So the result was that from when the Democrats got rid of the filibuster in the Senate for a couple of years, they began confirming circuit court judges over the objections of Republicans. The Republicans could no longer filibuster, and there was no longer a reason to moderate the picks with a gang of 6 or a gang of 9 because there was no filibuster. And it left the Republicans seething. So when the Republicans came into power in 2017, unexpectedly, with the Senate still in Republican hands, the Republicans decided that they were going to rush conservatives into the court. When the Republicans took back the Senate in 2014, as a way to protest what the Democrats had done by scrapping the filibuster, they simply stopped confirming judges. So massive vacancies opened in the federal court system because it was retaliation for the Democrats scrapping the filibuster. The Republicans weren't going to fill any more seats until after the election. And so when Donald Trump got elected and the Republicans kept the Senate, they began a concerted effort to fill as many seats as possible. So the Democrats, starting in 2017, started saying if they ever took back the White House and the Senate, they would pack the court. They would pack the Supreme Court. They've been making this argument now since 2018 with gusto that if they ever get back the White House and the Senate, they're going to pack the Supreme Court. So we now reach this point where the Democrats have been threatening to pack the court all the time as payback for the Republicans piling conservatives in, as payback for the Democrats scrapping the filibuster, as payback for the gang of 8 or the gang of 9 or whatever it was coming up with a reasonable compromise, as payback for the Republicans winning in 2002, as payback for George Bush winning in 2000 despite losing the popular vote. And the Republicans finally had enough. So this is the lay of the land as we come into the vacancy of Ruth Bader Ginsburg. Both sides have grievances against the other. I would argue the Republicans have more grievances against the Democrats for reasons I'll explain when we come back. But this is where the Democrats are. When they say they want to pack the Supreme Court, they want to add seats to the Supreme Court. If Republicans are able to shift the ideological balance of the Supreme Court for the first time since the 1980s, then the Democrats are going to add progressives to the Supreme Court to shift the balance back and decisively shift it to the left. If they do that, the Democrats will be the ones breaking down norms, not the Republicans. But, of course, the Republicans will get blamed.